dad in the law business? Was that something that you come by naturally?
That's a great question. It turns out that growing up, I didn't know that my father actually had a legal career. I grew up in the Pacific Northwest. My family immigrated to the United States from Taiwan. But growing up, my father, I just knew him as a cook in a restaurant, and slowly the details sort of came out, and I learned that my father had been a refugee as a child from mainland China when the communists took over, and he and his brother had moved to Taiwan, gotten there as refugees. And he eventually kind of worked himself up and decided he wanted to be a judge. And of course, in Taiwan, you go to school professionally and are trained as a judge, and that's what he did. He did in Taiwan, but not in the United States. In Taiwan, he, well, as he told me later, you take a test, and depending how you do on the test, you either start out as a baby judge in Taipei, or you end up resolving disputes involving chickens out in the countryside. And he did well enough that he was able to be a judge and serve in that capacity in Taipei for a number of years. But once we moved to the United States, that was something that was not possible for him to continue to practice law.
Was there a reason why he came to the United States?
That was complicated. I think that he had me. He wanted me and my sister, who came along a little bit later, to have an opportunity at a better life. And those were reasons to come to the United States.
There wasn't politics or any particular things?
There wasn't anything specific, although it's interesting you ask. I mean, he did talk about certain high-profile cases in which he felt some pressure to rule in the favor of the government, but he wasn't very specific about those kinds of things, and he certainly did seem relieved that he wasn't under that kind of pressure anymore. And his story had kind of spilled out, and I had absorbed that. It wasn't the thing that caused me to consider law school, I think, most directly. Going away to college, I attended UCLA after having grown up in the Pacific Northwest. I really got interested in politics and American history. And those two subjects really drove me to think about either grad school in politics or perhaps law school. I wasn't sure at that point. After some testing and some thinking about it, I ended up trying law first, and it took hold. I left UCLA and California for law school. I was able to attend Yale Law School, and that was a wonderful experience. That ended up kind of shooting me off in a different direction. I ended up clerking for federal judges in New York and Boston. First, a wonderful judge named Denny Chin, Obama appointee to Southern District of New York, who President Obama then elevated to the Second Circuit. He's there now. Then I had the chance to clerk for just a wonderful man named Hugh Bounds on the First Circuit in Boston. And for years, Judge Bounds, who was a Carter appointee, was the only federal judge in all of New Hampshire. And he was just a wonderful mentor as well in a very different way. But after that, I was trying to think of what to do, and had the chance to think about whether I wanted to work in a law firm or do something in the public interest. And I decided I wanted to be a crusading lawyer for a while. And a position opened up in Georgia. I went down there, and for about 3 years, I worked for the ACLU as a staff attorney. And those were just glorious years.
What time period?
So that would have been, I want to say 1999 to about 2002. Okay. Those were great years. Didn't really pay my loans much, but during those years, our office did everything from litigating against the electric chair in Georgia, and during that period, the Supreme Court of Georgia actually put an end to its use after I think over 100 years. We litigated all kinds of free speech cases. From kids who wanted to wear, Confederate flag T-shirts or Malcolm X T-shirts, to restrictions on Centennial Olympic Park in Atlanta. Some really fun things. After those years, I finally started to write and to sort of think more serious about becoming a law professor. And things worked out. I got my first gig out at the University of Oregon. Spent about 6 years out there, and that was about the closest to home that I had lived since I had left. And so those were wonderful years, and both of my children were born in Eugene, Oregon, so they were ducks. I think I first started writing a lot about the First Amendment from both a kind of theoretical perspective but also a historical perspective. Became very interested in how the First Amendment developed the way it has, why so many Americans feel so strongly about their First Amendment rights, whether it's right to free speech or freedom to worship, and why it is that Americans often put those rights above all others. So a lot of my early writing had to do with that, trying to figure that out. How do we arrive at a kind of constitutional culture where that could happen? And that was a lot of fun. And then my writing sort of, I think, took a little bit of a different direction. My next major project involved trying to understand more broadly why Americans love to write constitutions. And I got really interested in all the constitutions that we don't learn about, right? The ones that failed, the ones that were written by radicals, the ones that never got off the ground, but could still tell us something about the times in which they were written. And that's what became my second book, America's Forgotten Constitutions. So I started getting really interested in the Barnette case, I would say probably in between the first book and the second book. And some of this material that I ended up collecting made it into the first book. And I guess where Barnette sort of fits in my interests is, the opinion is such a masterpiece of writing, of legal writing, but also it prevents a kind of optimistic vision of society and of democracy at a moment in which we were at war. Not always easy to accomplish. And I think for all those reasons, Justice Jackson's opinion really has stood the test of time. I'm going to talk a little bit tonight about how maybe it could have been even a little bit better, which is hard to do with masterpieces, but no text is perfect, and it will turn out that when we think about the direction in which he originally wanted to take the decision, that his first instincts, I think, were even better. That before his colleagues kind of got their hands on his draft, that if we had had that opinion come out, we would have even more glowing things to say about it. Absolutely.
Okay. Oh my God.
Absolutely. So I was able to take a couple of trips to the National Archives. This was when I was still living out in Eugene, Oregon. And I spent time going through the justices' files there, and was able to put my hands on the memos that went back and forth. And in one of the important memos that I discovered, there was this early draft of his that was clipped to it, and of course comments from the chief at the time, Harlan Fiske Stone, advising him to tone down what he originally wanted to say. It turns out there were several paragraphs that were in there quite interesting. He eventually took them out. So we'll talk about those tonight. There were initials on one of the memos. I think it had initials, if I remember correctly, JFC, John Costello. Costello. And he seemed to be the one most involved in that particular opinion. Justice Jackson's words are among the most quoted in all of the Supreme Court opinions that we can find. It's a real testament to the way he wrote that opinion. Not only about dry constitutional principles, but rendered in a way that was really soaring, really beautiful, and as a result, quotable. He wrote an opinion in which people were able to sort of take it in a lot of different directions. And I'm going to talk a little bit tonight about some of the early reactions to it, which were far more positive than the reactions to the ruling that was overruled, right? The Minersville versus Gobitis decision. But I think it really is a testament to who he thought he was writing for. I think he was writing for more than just other judges. He was really trying to speak to average Americans, and I think he succeeded. There's positive things and negative things that motivate me. These days, the negative things that sort of get me up to do something about are the things I read in the news about the suffering of political minorities, some of the things that Justice Jackson himself warns us about, right? That in times of rising nationalism, there will be some groups that will have to suffer the costs of these moments, whether they're the dissenters, right? Or they're the religious minorities, or the religious minorities in our own day. So when I read in the news that one of those groups has suffered some indignity, that gets me up to think about how that problem can be confronted. So that's the sort of negative sort of thing that gets me going. The positive is I am motivated to, and here we're kind of getting into my third book, which will be coming out in February. Might be the fastest book I ever wrote. The book is called Practical Equality, Forging Justice in a Divided Nation. And you know, this book is sort of my effort to offer some optimism for people, for groups who feel as though these times are particularly hard for them. And what I talk about in this book is that there are a bunch of strategies that we've used in the past to try to take the edge off of these kinds of moments, right? There's only so much you can do when you're sort of going through a period like this, but you can sort of do things to sort of reduce the suffering that some groups experience. And so I talk about this. I talk about Japanese American internment. I talk about you know, what happened with the initiation of the Black Codes after Reconstruction. I talk about contemporary problems that we're dealing with, such as harsh treatment of undocumented migrants. I talk about the administration's restriction on Muslim travelers. So these are all the kinds of things that sort of raise problems of equality. And I suggest that there are a lot of different ways that we can think about kind of reduce the suffering that these groups face. You know, even if we can't solve the bigger problems, the philosophical problems of how to deal with their concerns, there are small things we can do. I hope that they walk out with a firm sense of what an amazing thing it was for the Supreme Court of the United States to reverse itself in such a short span of time. The first decision comes down in 1940, saying that the First Amendment, right, presents no obstacle to public school officials punishing Jehovah's Witnesses for refusing to salute the flag. And you know, just 3 short years later, they've done an about-face. This is a remarkable turnaround, one that requires us to, I think hard about the times, about how that happened, and also I hope that that people leave today with a sense for how understanding that moment can help us to think through some of the problems that we face in our own nationalist moment. And so we'll try to sort of tease out some of those lessons, and we'll see what folks think.